suppose all you need to add to that is so. Yeah, to be like it. So, but from what I understand, Lord Nelson at 91 years young, together with his walking stick, he brought down the house to Queen's Hall with that performance on Saturday night. All right, let's move along because it's already coming up towards 19 minutes after 6 o'clock in Trinidad and Tobago. We're joined now by Attorney at Law Martin George to get his perspective on the Privy Council ruling last week on the granting of bail for murder accused. That decision was upheld by the Privy Council. However, Mr. George says there is cause for concern and notes that since individual judges can use their own discretion to decide on each application, there may also be need for balance. Is it a Fitzgerald Hines kind of balance? Well, we'll find out. We'll also be discussing the murder of Achille Charles. It was his lawyer who advocated for the granting of bail, and we saw him being killed over the course of the weekend, being killed shortly after the matter was determined by the Privy Council. Martin George, very good morning to you. Thanks for joining us.
Yeah, hi, good morning to you, Fazil, and good morning, Trinidad and Tobago. And, Fazil, as you mentioned, the matter with Fitzgerald Hines and certain comments that were made by him in relation to emancipation, that represents the same level of palpable, potent stupidity which the former chairman of the PSC had tried to instigate when he suggested that, we need to balance the number of Afros and Indos in the police service, and he said that that was the mandate of the Police Service Commission. And if you recall, I was the first one who stood up in the parliament and spoke out against it and said, absolutely not. That's not our role and function. And similarly, I will condemn and castigate any attempt by Mr. Hines, either in his role as Minister of National Security or as a representative of the government or the political party which he serves. That's not the way things are done. What he should instead be highlighting is the achievements of Mr. Langston Roach, who was featured in The Guardian on Sunday, for his business success, and set him as an exemplar and pattern of success for young Afro Trinbagonian business persons to aspire to. That's what Mr. Hines should be speaking to, instead of speaking of this type of, interference, which really amounts to, a form of, like, sometimes almost reverse discrimination that you are trying to do engineering, social engineering in that way. So I certainly do not support that view at all. I think that we ought to be celebrating the heroes who have been successful in business, and that's what the government should be promoting and trying to encourage young Afro-Trinbagonian entrepreneurs. Give them the tools, give them the materials, give them the wherewithal, give them the access to funding, give them the training, the development. That's what they need, instead of you making these, statements on a political platform, basically, which is what he did.
I hear you on that, but I'm still going to get the Afro and Dashiki and change my name to Mamadou Diaba to put in my application to get a few more plots of land. But I mean, it is beyond ludicrous. But again, this is Trinidad and Tobago, and it's good that you mentioned the case with Nizam Mohammed as well, because that was mentioned by our producer, even as we were chatting about it off air. But it just seemed that we like it so. But okay. It's ridiculous. But anyway, let's deal with the substantive issue for which we invited your perspective. Just give us your thoughts or your concerns in relation to the Privy Council ruling.
Right. So the thing is, Fazil, what we have to recognize is that the Privy Council has basically said that, look, the granting of bail is really a judicial function. It does not, fall within the prerogative of the legislature to determine that. So in other words, if you have a provision in a law which says that, look, as a murder accused, you cannot be granted bail, then they say that infringes upon and erodes the judicial independence and the authority of that individual judge or magistrate to determine the issue of whether or not you should be granted bail. So it is a significant and a seminal judgment by the Privy Council. It means for sure that we are going to have to, beef up our delivery of justice within our system, because at the end of the day, once you have persons who have been languishing 10, 12 years on a murder charge, waiting for a court date waiting for their matter to start, then of course any magistrate or judge who's considering that will, prima facie be predisposed to be saying, well, hey, listen, if the state is taking so long just to even get your matter started, then maybe you ought to be entitled to bail. You see, so the thing is, it puts greater pressure on the judiciary and the entire judicial system, because it means that they have to step up their game, particularly with matters where persons are charged for murder, because if you don't do so, then they will be applying for bail en masse, and in many cases where they've been on remand for years and years and years with no possible plausible reason by the state as to why it is taking so long, then they will be granted bail. It's a plain and simple as that. I don't know why it is our system is so clogged, is so slow, is so toxic in terms of its stagnation. Because we see internationally, you see persons who are charged for murder, you see within a few months their matters are called, their matters are dealt with, and they're processed, and that's the end of the matter. So we really need to take a look within ourselves and within our judicial system, because that's where the pressure is really going to come in the months and years to come.
And I can already hear the government stooges in my head pointing out which countries have similar challenges as far as people being on remand for lengthy periods of time, as if that in some way excuses our situation. But in any event, before we if time allows, get to that issue, do you have concerns about the exercise of discretion by the judges when it comes to the granting of bail? Because obviously it still comes down to a judge's discretion, doesn't it?
Yes, it does. And so what the Privy Council has done, they've restored that right to the judges, the magistrates, the masters, that they are the ones who will determine the issue of bail. Now, what it also means is that they will have to consider all the relevant factors. And I don't think that in Trinidad and Tobago, we have a history of particularly bad decisions in terms of the exercise of that discretion to grant bail. Of course, we've had a few notable exceptions. If you recall the Brad Boyce case, where immediately after the dismissal of that matter, it was said that he fled the country, and hasn't been heard from since. We had the Uncle Khaled case, where he disappeared. So the point is, apart from a few exceptions, I don't think there has been any particularly egregious instances where you have had the grant of bail being abused in that way. So I think I can trust, and I think we as a nation can trust our judiciary to do the right thing more often than not in terms of the grant of bail and the exercise of that discretion. But where I am saying to you, the pressure is in terms of the expeditious disposition of these matters where persons are charged for murder, because you routinely have the officers from the DPP's department coming to court and asking for adjournments. They haven't gotten the file, no attorney has been assigned. Or they've just been assigned to the matter, or the attorney's on vacation, the attorney who was on it left. And, listen, it's replete with the plethora of excuses that they come with each and every time asking for an adjournment of the matter because they are not ready. Then, of course, you may have those where persons may file applications to the High Court, seeking judicial review or some other judicial intervention, and that may stall or delay the matter. Of course, that's no fault of the state, but then those things all add up cumulatively to the length of time someone might be incarcerated for waiting for trial for murder. And that then puts more pressure on the presiding magistrate, master, or judge who has to decide on the issue of the grant of bail.
And correct me if I'm wrong, please, Martin George, because didn't we hear from the DPP's office earlier this year when this process was being started? Again, I will apologize immediately if I'm misrepresenting the situation. Didn't the DPP's office say that they are not ready the DPP said that they are not adequately staffed to deal with the greater workload that would come from this process now reaching where it is at this stage?
Well, I think he even complained about their present workload and their present lack of resources, lack of sufficient staff, and lack of, adequate resourcing. So therefore, this is only going to make it worse, because the fact of the matter is that you are now under this time pressure, this public pressure, because when you see persons who have been charged for particularly heinous crimes who now are going to be applying, and some of them will be granted bail, because you see, it's not just the nature of the alleged crime. You have to consider the time they've been inside, the time they've been awaiting trial, who has been responsible for the delay. And if it's shown that it's the state that is largely responsible for the delay, which is the case, I could tell you as a fact for you, in most of the matters, it's the state that is usually the one who's not ready. So therefore, in those cases, you are going to see more pressure on the DPP's department, because then people are going to be pointing fingers and saying, well, hey, listen, it's because y'all were not ready. That's why you had the long delay. That's why this person was granted bail. So it really, I don't envy Mr. Gaspard and his task at all in that regard.
And just before we develop this point about our judicial process and the system in itself, and whether or not this could actually be a trigger for them to sort out their act, at least on the state side of things. I mean, we've seen the murder of Achille Charles because it was his legal representation and argument for bail that has brought us to where we are at. How do you place this very sad situation in context?
Well, for the sad reality is that it is a reflection on the state of our nation, in that a young man like Achille Charles was actually safer behind bars than he was on the outside. So, take a minute to digest that. As a murder accused, you are safer within the prison's walls than out in the public. So then what does that leave for us, the ordinary citizens? Where is our safety and security? If it is that, you're talking about someone in his scenario who, within a week of him coming out of prison, he is murdered, then it means that the crime is so rampant out there for you. It is so random, it is so, sporadic, that each and every one of us will someday be affected by it in one way or another. And that's why I called upon the commissioner of police, and I put out a challenge to him, because, I'll tell you something. Our safety and security ought to be our number one priority as a nation. When you talk to foreign investors, you talk to persons internationally, the first thing they ask about, because in other words, that's the image that sometimes people get out there of Trinidad and Tobago, that look, hey, in terms of crime and safety, it's a nightmare. And we need to get that right. We need to fix that one way or the other. And, I am still trying to wrap my head around the Prime Minister's, opaque and oblique suggestion that crime should be declared a public health emergency. And I'm trying to figure out, how is that going to be a solution to crime? Okay, so we declared a public health emergency, then what? But he seems fixated on the idea, because I heard him repeat it another time. So, it seems that somehow he has a bee in his bonnet about that, but he's not providing us the solutions, the tools, the framework to be able to say, well, okay, look, how declaring it a public health emergency is going to be the solution. I am still waiting to hear from the Prime Minister. I know he's, recuperating from COVID, so of course we'll give him the opportunity to rest and recuperate, but I look forward to hearing from him when he's better as to how that is the solution.
We probably will give FitzCity a chance to give us a lucid explanation on that. But let's wait and see. But let's get the time that we have available. You're a practicing attorney at law. You would interact, whether socially or otherwise, with a lot of these judicial people and so on. It don't bother them the way the system is. Do we have to say, well, maybe you all should spend time in remand to understand what it is like to be languishing in remand for months or years, waiting on your matter to be heard? I know it will sound callous, but is it that these people are so caught up in their lofty towers and clinking glasses, drinking their brandy and whatever it is in those circles, that they don't associate what they do as a job to the fundamental running of a nation as far as law and order?
Well, I could say definitely for most of the judicial officers, no, for you, that's not the case. Most of them are actually acutely aware of the atrocious conditions that prisoners face, or that persons who are accused and awaiting, trial, that the horrors that they face. And we have actually several judgments where judges have actually expressed their dissatisfaction and displeasure with the conditions in the prison system, the lengthy delays awaiting trial. So I think, in fairness to our judicial officers, they do have a very acute understanding of the circumstances, and they do what they could from their end. But you see, remember, the judicial process, it's an entire, panoply of, players who are responsible for different segments of it, and therefore it's not just the end product when you come to court. When you come to court, I think that's the easiest part. But the point is getting ready for that. That's where I think most of the delay occurs.
I hear you on that. So what is the solution, Martin George? What is the solution if we're talking about police dragging their feet on investigations, or not turning up in court when it doesn't matter, having to be adjourned endlessly, and forensics taking forever, ballistics taking forever squared. DNA testing, something not working, or whatever it is. I mean, as you said, it's a panoply. It's a buffet of issues that we are left to digest.
Yeah. All right. Okay. So I would tell you few practical suggestions that I have floated from time to time. I have said, number one, remove all police prosecutors from the magisterial court system. The police prosecutors, with all due respect and all credit to them, they do not have the full training most times as practicing attorneys. So therefore, you ought to have practicing criminal attorneys as the prosecutors in the courts, not police officers. So that will help to speed up things, because many times, I'll tell you, I've seen situations where you make a legal submission and the police officer is flummoxed. He just doesn't know his head from his toe, whether he's going or coming, because the point is, he does not have that legal training. No fault of his, if you understand. So therefore, this idea of police prosecutors, I think we need to do away with it totally. We have enough young attorneys floating around the place, enough young attorneys who are seeking employment, who would be willing to, join the DPP's department and do the prosecutorial work in the magisterial level. So therefore, that's the first thing I would say. Get rid of all the police prosecutors. Have attorneys from the DPP departments prosecuting each and every matter in every court. That's one. Number two, you need to beef up the public defender system, which I saw was implemented, that along with the legal aid system, in the sense that once you have that system working properly, you cannot have an accused person come into court and then now trying to give an excuse to say, well, he's not ready because he doesn't have an attorney and he needs time, and you're taking 7 and 8 months to have an attorney appointed by the legal aid authority. So again, we have lots of young attorneys floating around, lots of young attorneys seeking employment. Give them those jobs, let them come out, let them do the work, and let them be ready. The next thing you have to look at, so that's 2 I gave you. 3, we need to have a system where you have a magistrate assigned to deal with the list in court and a trial magistrate. So each court ought to have 2 magistrates, one who is sorting through the list. Because I'll tell you, for you, when you have a magistrate come in and sitting in a court with a list of 40-something or 50-something matters, and then still having to do trials, you never ever really get around to doing any trial. Because you just don't have the time. So therefore, you need a separate magistrate to go through the list, and therefore, for your trial magistrate, you have maybe 1, maximum 2 matters fixed for the day. So therefore, everybody knows on that day, at that time, that matter is going on. Because I tell you, many times you have attorneys and state prosecutors who come to court almost with the expectation that they will be granted an adjournment as a matter of course. So that needs to stop. In the civil jurisdiction, it was done with the introduction of the CPR, right, by late Chief Justice Sharma. That was his pet project, to introduce the CPR, and it has been followed on by the current CJ, Justice Ivor Archie, and that has actually helped to speed up the justice delivery in the civil side of things, we need to ensure that the criminal proceedings rules, which we have in place, but which are not yet having that, effect in terms of the expeditious delivery of justice in the criminal side, we need to ensure that that works in a similar manner to move things along in the criminal arena.
Well, I'm glad you clarified what CPR is, because I thought you meant cardiopulmonary resuscitation, because I think that's what our judicial system needs.
Well, I think the judicial system needs that.
So criminal proceedings rules and cardiopulmonary resuscitation. Maybe they should play Staying Alive from the Bee Gees every time they start a process, because that is the beat for CPR. So, yeah, I mean, we might be smiling, Martin George, but it is very distressing. The way the situation is, but time doesn't allow us to develop the discussion any further, but maybe just as well. But we do appreciate you, as always, taking the time to chat with us this morning.
Thanks a lot. It's indeed a pleasure.
Take
Have
care,
a great day.
Martin George. And again, just something as simple as what was proposed by former Port of Spain Archbishop Joseph Harris. If fellas in remand for longer than if they would have been found guilty for their matters, shouldn't they be released? But just that simple common sense suggestion can't gain any traction in this place called Trinidad and Tobago. Certainly not with our legal luminaries. Think about it. Somebody gone in there with a joint. And, okay, just a matter of maybe 6 months or whatever. But inside there for years. So it's been in remand for much longer than if they had been found guilty. And you all can't find a way to work that out? Or you're really not serious? 6:40 in Trinidad and Tobago. Let's take a break. Here we have a submission from a Trin City viewer who spent some time in the Sister Isle. Tobago waters very, very calm at that time when our viewer was in the Sister Isle. We'll be right back.